One of the most serious traffic cases in Virginia is driving under the influence, also referred to as drunk driving or DUI. The high incidence of alcohol-related traffic fatalities is the main reason why judges and prosecutors take such a firm position on DUI charges. Another driving factor behind tough DUI laws is powerful special interest groups with strong lobbyists pushing politicians to pass more and more onerous DUI laws. In fact, some prosecutors will not offer a plea deal on any DUI charge. While DUI is commonly referred to as drunk driving, it is possible to be under the influence of either drugs or alcohol. In alcohol cases, the driver is presumed to be under the influence if his blood alcohol content, or BAC, is 0.08 grams of alcohol per liter of blood or higher. However, this does not mean that if your blood alcohol content is lower than 0.08, that you cannot be convicted of a DUI. It is also a violation of the law to unreasonably refuse to give a breath sample or to have a blood sample taken. If found guilty of this offense, you will receive an additional 1-year suspension of your license for the first offense. If arrested for DUI or refusal, your driver's license will immediately be suspended for 7 days. For a subsequent offense, it will be suspended for 60 days or until you have a trial. While an officer only needs probable cause to arrest you for DUI, the court must find you guilty beyond a reasonable doubt. Here at John W. Lee PC, we look at several factors in defending DUI cases. First, was the traffic stop a valid stop? An officer can only pull you over for observing a traffic violation or stop you at a properly conducted DUI checkpoint. Second, what was the driver's blood alcohol content? This is important in determining guilt, as well as determining what the sentence may be if you are convicted of DUI. Third, did the driver make any statements to the police? Remember that any statements that you make to the police can and will be used against you in court, regardless of if those statements were made before or after your arrest. If you are found guilty of a first offense driving under the influence, you will receive 1 year suspension of your driver's license, up to a $2,500 fine, and up to 12 months of jail time. If you have a blood alcohol content of 0.15 or higher, you also run the risk of receiving mandatory minimum jail time, meaning that the judge cannot suspend those mandatory days and the judge must require you to serve that jail time. Also, the judge can order you to install an ignition interlock system on your vehicle to measure your BAC before being able to start your car. A second offense DUI carries even more severe penalties, including mandatory jail time, mandatory minimum fines, and a 3-year suspension of your driver's license. A third offense driving under the influence is considered a felony in Virginia. As such, it carries a minimum of 90 days in jail and an indefinite suspension of your license. Indefinite suspension means that you will not get your driver's license back until a court decides to give it back. You should never go into court on a DUI charge or any other criminal charge without proper legal representation. Call John W. Lee PC if you have been charged with a DUI.